If your family has been waiting years to reunite across borders, if you have been tracking priority dates every month with a mix of hope and anxiety, and if you have seen headlines in February 2026 about DNA expansion and priority shifts that left you worried about what comes next, then this video is for you. My name is not important, but my commitment to you is. I am a senior U.S. immigration attorney with over 25 years dedicated exclusively to family-based immigration. I have guided thousands of U.S. citizens and lawful permanent residents through the intricate world of I-130 petitions, adjustment of status applications, consular processing, and the critical protections offered under the Child Status Protection Act. My goal today is not to alarm you or to engage in political speculation. My goal is to explain how these February 2026 updates actually protect the integrity of your family's petition and to help you understand what steps you can take right now to keep your case moving forward with clarity and confidence. Let us take a breath together. I know that waiting to bring your loved ones home can feel unbearable. You watch the calendar, you check the visa bulletin each month, and you wonder if the timeline will ever shorten. You may have elderly parents who long to spend their remaining years near you, or children approaching their 21st birthday, whose futures hang in the balance. The emotional weight of family separation is real, and I see it every single day in my practice. But here is what I also see. The foundational principle of U.S. immigration law remains unchanged. Congress and the agencies administering these laws continue to recognize family unity as a cornerstone of immigration policy. The updates we are discussing today are procedural refinements designed to strengthen the credibility and efficiency of the family-based system, not to dismantle it. So as we walk through the technical details, please remember that the law is still on your side and preparation remains your greatest ally. The first significant change that families need to understand is the February 2026 I-130 processing reprioritization. USCIS has announced an internal shift in how it allocates resources to adjudicate family-based petitions. The agency is now focusing more heavily on clearing backlogs in the immediate relative category. Who falls into this category? Immediate relatives are the spouses of U.S. citizens, the parents of adult U.S. citizens, and the unmarried children under 21 of U.S. citizens. These are the relationships that Congress has designated as exempt from numerical visa caps, meaning there is theoretically no limit to how many immediate relative visas can be issued each year. Because these petitions do not require waiting for priority dates to become current, USCIS is concentrating resources on processing them as quickly as possible. Now, you may be asking yourself, what does this mean for me if I filed under a preference category such as F2A or F2B? The F2A category covers spouses and unmarried children under 21 of lawful permanent residents. The F2B category includes unmarried adult sons and daughters of lawful permanent residents. These categories do have annual numerical limits and require you to wait for your priority date to become current. The reprioritization does not change your eligibility. It does not invalidate your petition. What it means in practical terms is that USCIS adjudicators may spend more time on immediate relative cases, and this could create a ripple effect that slightly extends the processing time for preference category petitions. I want to be very clear about this. Your place in line, your priority date, and your statutory right to immigrate remain fully intact. This is an internal resource allocation decision, not a change to the law itself. If you filed your I-130 petition years ago and it was already approved, nothing about that approval is affected. If your petition is still pending, continue to monitor processing times on the USCIS website and respond promptly to any requests for evidence. Patience, as always, is required, but patience grounded in legal knowledge is far more sustainable than patience driven by fear. The second major update that has generated considerable attention is the expanded Biometrics and DNA proposal, introduced in February 2026. I want to address this calmly and factually. USCIS and the Department of State have proposed expanding the biometric data collected during family-based immigration processes to include advanced measures such as iris scans, voice prints, and in certain circumstances, DNA verification. This expansion applies not only to the beneficiary, the person immigrating, but may also extend to the petitioner and to certain minor children listed on the application. Why is the government doing this? The stated rationale is straightforward. Identity fraud and relationship fraud remain persistent challenges in family-based immigration. There have been documented cases where individuals have submitted fraudulent birth certificates, marriage certificates, or other documents to establish relationships that do not exist. DNA verification, when used appropriately, provides an objective scientific tool to confirm biological relationships. Iris scans and voice prints add additional layers of identity assurance that are far more difficult to falsify than photographs or paper documents alone. I understand that some families find this proposal intrusive or unsettling, but I want you to understand that this is not a presumption of guilt. This is not the government assuming that your family is fraudulent. This is an integrity measure being applied broadly across the system to ensure that the privilege of family-based immigration is protected for those who have legitimate claims. If your relationship is genuine, if your documents are authentic, then these biometric measures will only serve to confirm what you already know to be true. You should cooperate fully if asked to provide biometric data. You should not interpret a request for DNA testing as an accusation. It is simply part of the verification process in an era where technology allows for greater certainty. My advice is to view this as one more step in your journey, a step that ultimately strengthens the system that allowed your family to petition in the first place. Now let us turn to one of the most critical protective mechanisms available to families with children who are approaching their 21st birthday. I am speaking, of course, about the Child Status Protection Act, which we call CSPA. This law was enacted specifically to prevent young people from aging out of eligibility through no fault of their own. The core principle of CSPA is that a child's age can be frozen under certain circumstances, allowing them to retain their status as a child even after they turn 21. But understanding how CSPA works requires careful attention to the details, because the calculations and deadlines are strict. Here is how you calculate CSPA age. Take the child's biological age on the date that the priority date becomes current and subtract the number of days that the I-130 petition was pending with USCIS. That subtraction gives you the child's CSPA age. If the CSPA age is under 21, the child is protected. Now, let me walk you through an example to make this concrete. Suppose you filed an I-130 petition for your child on January 1st, 2022. USCIS approved that petition on July 1, 2023. That means the petition was pending for 18 months, or approximately 545 days. Now suppose your priority date becomes current in March 2026, and at that moment your child is 20 years and 8 months old, or roughly 7,545 days old. You subtract the 545 days of pending time. Your child's CSPA age is now 20 years and 2 months, which is under 21. Your child is protected, but there is a second critical requirement. Once the priority date becomes current and the child is offered the opportunity to apply for adjustment of status or an immigrant visa, the child must seek to acquire permanent residence within 1 year. This is called the Seek to Acquire requirement. Seeking to acquire means actually filing the I-485 adjustment application or attending the consular interview within that 1-year window. If you delay beyond 1 year, the CSPA protection can be lost, and the child may age out even if the initial calculation showed protection. This is why timing is everything. You must be ready to move quickly when your priority date becomes current. In February 2026, the Visa Bulletin published 2 charts as it often does. The first chart is called Final Action Dates, and the second is called Dates for Filing. The Dates for Filing chart is particularly important for CSPA purposes because USCIS sometimes allows applicants to file their I-485 applications early based on that chart, even if the final action date has not yet arrived. Filing under the Dates for Filing chart can freeze a child's age at the time of filing, which provides an additional layer of protection. My strong recommendation is that you monitor both charts every single month. If USCIS announces that it is accepting I-485 filings based on the Dates for Filing chart and your priority date falls within that window, you should file immediately. Do not wait. Every day counts when a child is nearing 21 years of age. Prepare all of your documents in advance. Have your medical examination completed. Have your financial documents ready. The moment the window opens, submit your application. This is not a time for procrastination. This is a time for decisive action. Another development that many families have encountered in 2026 is an increase in 221G administrative processing notices at consular interviews. If you or a family member attended an interview at a U.S. embassy or consulate and received a 221G notice, it can feel like a denial, but it is not. A 221G notice is an administrative hold. It means that the consular officer requires additional information or additional time to review your case before making a final decision. This is procedural, not a refusal. In many cases, 221G holds are issued because the consular officer wants to verify documents, conduct a more detailed security check, or review your online presence to ensure consistency with the information you provided in your application. The increase in 221G notices in 2026 appears to be driven by enhanced document verification protocols and expanded online presence reviews. Consular officers are now routinely examining social media profiles, public records, and other digital footprints to cross-check the statements made during the visa interview. If there are inconsistencies, or if the officer simply needs more time to evaluate the evidence, a 221G hold is issued. My advice to families who receive a 221G notice is to remain calm and responsive. Read the notice carefully to understand exactly what additional information or documentation is being requested. Provide everything that is asked for as quickly and as thoroughly as possible. Do not assume that silence means your case has been forgotten. Administrative processing can take weeks or even months, but most cases that enter 221G status are eventually resolved favorably. This is a pause, not a final no. Treat it as an opportunity to demonstrate the strength and authenticity of your case through complete and accurate documentation. Let me also address the public charge rule and income thresholds, because financial eligibility remains a frequent source of confusion and anxiety. Under current regulations, a petitioner who is sponsoring a family member must demonstrate that they have income at or above 125% of the federal poverty guidelines for their household size. As of February 2026, for a household of 2 people, that threshold is approximately $25,550 per year. If you are sponsoring your spouse and you live alone with no other dependents, your household size is 2, and you must show income of at least $25,550 annually. But here is what you need to understand about the public charge analysis. USCIS does not make decisions based solely on income. The agency is required by law to consider the totality of circumstances. This means they will look at your age, your health, your education, your employment history, your assets, and your family support. If your income falls slightly below the threshold, but you have significant savings, or if you own property, or if a family member is willing to serve as a joint sponsor, these factors can overcome an income deficiency. A joint sponsor is someone else, often a family member or close friend, who meets the income requirement independently and is willing to sign an affidavit of support on behalf of your beneficiary. Joint sponsors are a legally recognized safety net, and they are used successfully in thousands of cases every year. Do not assume that you are disqualified simply because your income is modest. Work with an attorney to present the strongest possible financial picture using all available tools, including assets, joint sponsors, and evidence of your work history and stability. Before we conclude, I want to clarify an important distinction that sometimes causes confusion. When we talk about priority date movements and visa availability, we are talking about the final step in the immigration process, which is either adjustment of status if the beneficiary is already in the United States, or consular processing if they are abroad. But the I-130 petition itself, which establishes the family relationship, can still be filed and adjudicated, even when visa numbers are not immediately available. In other words, you can and should file your I-130 petition as soon as you are eligible, even if the priority date in your category is backlogged by several years. Filing early establishes your place in line and starts the clock on CSPA calculations. Do not wait for visa numbers to become available before filing. That would be a strategic mistake. Similarly, if you have concerns about consular processing delays or administrative holds under 221G, Remember that these delays at the consular stage do not affect the validity of your approved I-130 petition. Your petition remains approved. The relationship has been established. The consular officer is simply completing the final verification steps before issuing the visa. This distinction is important because it helps you understand where in the process delays are occurring and what you can control versus what you must simply wait for. I also want to address the question of reciprocity and document standards. In 2026, U.S. consulates have increased their scrutiny of foreign civil documents, including birth certificates, marriage certificates, and divorce decrees. Some countries have histories of widespread document fraud, and consular officers are now applying stricter standards to ensure that documents are genuine. If you are petitioning for a family member from a country with known document integrity issues, expect that your documents will be examined very carefully. My recommendation is to obtain certified copies directly from the issuing government authority, to have them translated by a certified translator, and to include any available corroborating evidence, such as hospital records, school records, or religious records that support the authenticity of the civil documents. Do not cut corners on documentation. The quality and authenticity of your documents can make or break your case, especially in the current environment of heightened scrutiny. Let me close with a few words of perspective and encouragement. Bringing your family together is a journey of patience, preparation, and persistence. The February 2026 updates, whether they involve processing priorities, biometric expansion, or enhanced document review, are procedural adjustments designed to maintain the integrity of a system that has reunited millions of families over the decades. These changes do not reflect a fundamental shift away from family unity. They reflect the government's ongoing effort to balance accessibility with security, speed with accuracy. Your job as a petitioner or as a beneficiary is to stay informed, to respond promptly to requests, to maintain meticulous records, and to seek guidance when the rules feel overwhelming. I know that the wait can feel unbearable. I know that checking the visa bulletin each month and seeing minimal movement can be disheartening. But I also know that the law continues to recognize the importance of family relationships and that thousands of families successfully navigate this process every single year. You are not alone in this journey. There are attorneys, non-profit organizations, community groups, and online forums where people share experiences and strategies. Use these resources, ask questions, advocate for your family, and above all, do not let fear or misinformation paralyze you. The rules are complex, but they are knowable. The timelines are long, but they are finite. The system is imperfect, but it is functional. Before I end, I want to offer a brief but necessary disclaimer. The information I have shared with you today is intended for educational purposes only. It is not individualized legal advice, and it should not be relied upon as a substitute for consulting with a qualified immigration attorney who can review the specific facts of your case and provide tailored guidance. Immigration law is highly fact-dependent, and small differences in your situation can lead to very different outcomes. If you have questions about CSPA calculations, public charge analysis, consular processing delays, or any other aspect of your family-based petition, please reach out to an experienced immigration attorney in your area. I would love to hear from you in the comments. How long have you been waiting for your priority date to become current? What category did you file under? What country is your family member immigrating from? Sharing your experience not only helps me understand the concerns of the community, but it also allows others who are in similar situations to feel less alone. Thank you for watching, and I wish you and your family patience, strength, and ultimately reunion.